Or does call the case, people of the state of Michigan versus Zachary Radcliffe. Counsel, state your appearances.
Good afternoon, Your Honor. Amy Reiser on behalf of the people.
James Thomas on behalf of Mr. Radcliffe, Your Honor.
All right. Mr. Thomas, this is the defendant's motion, so you may proceed.
Thank you, Your Honor. Would you prefer me at the podium, or since I'm spread out here, can I do it?
Either way.
Judge, I'm going to start off with just talking about where we're at as far as this motion is. As you're probably aware, my client's been incarcerated for about 105 days at this point. He currently has a $3 million bond, which under the circumstances I feel is unreasonable. And I think that once we talk a little bit about what the evidence is in this case, because obviously part of our burden under the law is to show that there isn't a great amount of evidence, or that the presumption is great, that the evidence of guilt is there. And to go through that, Your Honor, what I'm going to do is I'm going to kind of surmise the evidence a little bit here from what we've looked at. And I would tell the court, as of just yesterday, I just received another supplement in regard to this case.
All right.
Of course, the last time we were here on the 9th of January, I believe that was the last PCC. The last time we were here, I had asked whether there was any other outstanding warrants that were involved or anything. And then I became aware that now I guess there's some Snapchat warrants. But at any rate, Your Honor, just to go through a cursory account of what I believe is not great evidence or a presumption of guilt in this case in regard to the evidence, simply would turn and talk about the FBI report that was given to us, where one of the victims in this case went to the FBI to lodge a complaint, which was really the beginning of this case. And upon a cursory review of that particular investigation that was conducted by the FBI, they found that they didn't have any Facebook or YouTube channel or Instagram. Everything was negative or for derogatory information in regard to that. Notwithstanding that, and again, this is me reading this report, that this allegations that were made were like multiple sessions that allegedly occurred. But when the investigation went back to the state police, it's one time. So there's a difference in that, and obviously there's no evidence that it's years ago, over 10 years ago, whatever it was. So that was the beginning, which led into other things. Going into an investigation for Yahoo, and going into his email address, going into all these videos and whatnot that were alleged to have been passed back and forth between the different alleged victims and whatnot. There is no CSAM. So there's no CSAM in this case that is in my possession that I've seen at all. And obviously that's a problem, because back in November, as you're aware, there was a 12 count complaint that then turned into a 31 count complaint. And the magnitude of charges doesn't make this case any more significant. You can't continue just to stack charges when you don't have the evidence to prove that CSAM. They need CSAM to prove their case, and they don't have it. They don't have any of this stuff. So the presumption, the evidence of guilt is not there. And again, I'm going to get into the other part of the hurdles of this case, but it's not there. We don't have any of this stuff. Going to, again, looking at the Google ones that were sent out, nothing. There's no evidence in regard to any of these transactions that were allegedly occurring between the people that are involved in this case and the defendant in this case. Now, the court is obviously well aware that when you're charged with capital offense, obviously part of this for us to show that there's a lack of this evidence. Well, we got the response from the prosecutor's office yesterday in regard to our allegations in our motion, and I'm sure the court, I don't know if you've had an opportunity to review it or not at this point.
I have.
But here's the part that I have a big problem with, Judge. When 6, 7, and 8 are the meat and potatoes of our motion, which the prosecutor's office answers they can neither admit nor deny. And obviously, you can't admit or deny and then put put that, we need to show our proofs on this, totally shifts the burden to us. We don't have a burden. The standard of proof for us is nil. We have to prove nothing in this case, Your Honor. And I just, I find it kind of, you know, as a, almost 28, as a 28-year-old lawyer, I find that kind of, you know, kind of disingenuous. The answer being either we don't admit or deny when you have a 31 count complaint that my client's facing with a $3 million bond that can't get out of jail is not reasonable. I just don't think that that's right. If you're going to deny something, that's fine. I don't have a problem with the denial, but not admitting and not denying as to the basics of why my client is incarcerated, I have an issue with. And so I want to, you know, I hope that the court will take that into consideration, you know, when considering whether or not we've met that, you know, met the standard that this case does not have the evidence that it needs to continue to hold my client on a $3 million bond. The court was given, you know, today, I don't know if you had an opportunity because there was 11 letters that I submitted as a supplement this morning, Your Honor.
Counsel,
I
you haven't been before me, but I read everything. So yes, I've read.
Okay. Well, and I appreciate that, Your Honor. I also, and I don't know if you'll, I showed this to the prosecutor. These are like 6 or 7 more letters. I don't expect you to read them right now, Your Honor, but can I approach it as,
Any objection to the court receiving the additional letter?
Judge, I have a copy of them. I can later on do another supplement and admit them
All right.
to the clerk's office, Your Honor. So let's talk a little bit about the flight risk. And I think that, you know, with the danger of the community and whatnot, the things that the court would be concerned about, obviously, to make sure that my client shows up for court. So we have all those letters of support, you know, as far as my client goes. You know, he is a lifelong resident here in Michigan. He's never lived anywhere else. He doesn't have a passport. You know, he doesn't have, he's indigent.
Didn't he live in Virginia or no?
No, he never.
No. Okay.
He went to school there, but you know, when you're a student, you don't have to.
Yeah, but I mean, he was there at Liberty, right?
As
Or
a student,
no?
I believe, Your Honor.
Okay, but okay. I just want to make sure that while he may have been a Michigan resident, there were periods of time where he resided out of state. Is that right?
It's fair enough. Yeah.
Okay. All
That's
right.
fair. I've always known it, whether you're in the military or if you're a student out of state, you're not really a resident of that state unless, you know, unless you claim to be a resident of that state. Because you don't have to get a driver's license from that state if you're either in the military or you're a student. I don't know if the court knows that or not, but I know for, you know.
I attended school out of state. It may have been back with the dinosaurs, but same rules apply. Go ahead.
All right. Well, his ties to the community, obviously his family, friends, I mean, he has all these people that are sitting in these rows here in his support here today, Your Honor. I'm sure some of them that are here wrote some of those letters. You know, he's not going to be a play risk. He's not going to be going anywhere. And, you know, obviously I'm his attorney, and I'm going to be on this case to its conclusion. He doesn't have a history of any alcohol abuse or drug abuse or anything like that. He's never even used any of that stuff. You know, there's allegations from some of the people in this case that he has, but there's absolutely zero evidence of that. And you know, obviously, you know, my client would obviously tell you that he does not have any issues whatsoever with any of that stuff. And he doesn't have a criminal record and no juvenile record in furtherance of that. So these are things that I think would be important, you know, to the court. You know, obviously we feel that he could get a job doing something if he were to get out. He doesn't even need to stay in this county. He has a sister who lives in Lenawee that he could stay with if need be. That, you know, and obviously the other thing would be, you know, if he needed to wear a tether or something like that, he would be, you know, he would do anything the court would require him to do. I'm also going to talk a little bit about, you know, the risk, the outside risk to the community, you know, and again, just because you file a magnitude of charges on somebody doesn't mean that you know, you can file 100 charges on somebody. If you don't have the evidence to prove those, you can't just say, well, the magnitude of charges merits a high bond. That's ridiculous. It shouldn't work that way. Bail doesn't work that way. I would also cite the court to, to a case, which is the People versus Davis. It's a Michigan Court of Appeal case from 2021. Basically, that under Michigan law and under the Constitution of our state, that you have a right to reasonable bond and reasonable bail, and based on your circumstances. And my client's indigent at this point, so a $3 million bond is tantamount to zero bond. I mean, even if it was $1 million, it's still tantamount to no bond. Well, lastly, Your Honor, I'm going to talk a little bit about, we had an evaluator go in there, psychology, Dr. Schaefer, Kathleen Schaefer, who I believe, and I'm not from Washington, but my understanding from my communication, unless I'm wrong, that she's been a doctor for the prosecutor's office also, and so in Washington. I don't know if that's true or not, but I believe that that was something that she proffered to me. But she's also went in and saw my client. I attached the 4-page report. I'm not going to go into the report, read it to you or anything. But obviously, he's a very low risk for repeat violence. She scored him as low on everything, pretty much, Judge. And obviously, we had that done for the reason of this hearing. And I think that taking that into consideration, the court can certainly take other measures to make sure that if he were released on some type of bail, that no contact orders and all these other things that the court has an absolute right to implement and put on my client to make sure that he's going to not only comply with the court's orders and showing up in court and doing what he's supposed to be doing while this case is ongoing, but also, obviously, it would be a great help to go through this evidence and prepare for this case, in the upcoming court date, and that's going to be very important to our defense and being able to be properly prepared to defend this case. And again, Your Honor, just looking at the evidence, I submit to this court that you can point a finger and collaborate and do whatever you want, but just pointing the finger, it's just an accusation. And accusations where the investigation that was conducted in this case, with all these things that were supposed to be passed back and forth, that not one thing has been passed, either from him, which would also, which I didn't bring up, but which also would include a VHS, a camcorder, 7 VHS that were found in his house, and he had no time to try to hide anything or clean anything up or do any of that stuff. His house was search warranted, and they went in there and confiscated all this stuff, and still didn't find anything. So, on top of that, Your Honor, I would just say that, obviously, if the people that are making the allegations said that they sent things through ISPs or IP addresses and through their email or through that, and yet the prosecutor's office has had the opportunity to do all these things, subpoena all these records, try to get all this stuff and not be able to produce one piece of solid evidence, and then say, well, we don't admit or deny to any of these allegations. It's because they can't, because they don't have the evidence. So, Your Honor, I'm asking the court today that, what I would think would be a reasonable bond for my client would be, $10,000 in that range, and possibly, he a tether or anything else would be amicable to any of that, Your Honor.
All right.
Thank you.
And
Yes, sir.
had a couple quick, and so that you understand both parties, sort of what the court's analysis and looking at the issue of danger to the community and the flight risk. When I go through the prosecutor's response, some things kind of jump out at me. Okay. One of those being, there's a lot that kind of jumps as it talks about the particular victim. But when the behavior as I see it laid out is certainly I mean, and I know they're going to have to prove their case, but um, is very predatory in terms of sort of the connection of the alleged victims in the case. Okay, so that's one issue that is the court. One of the other things that the court takes into account, because, unless there's been some prior behavior on the defendant in terms of that they're going to, that they have fled or not appeared for a court proceeding or those kinds of things where the court can see past behavior directly related to the court. One of the things that the court looks at is, does the individual do things that in the court's mind may either lead or obstruct an investigation or do something that might be obstruction of justice? So that's something that, and I would tell you that the court looks at that. Where I weigh it depends on the particular case or the nature of the case.
Do you have an example, Your Honor, of what you're talking about?
Well, if you look through the prosecutor's response, there were, and I guess I wanted to get the defendant's response to it, which may just be it didn't happen, but there are indications that during, and at what point in the investigation, I'm not sure, that there were calls or communications from your client to individuals that are now alleged victims in this case, to, if they're contacted, to not say anything, or if contacted, to support the defendant.
Right.
And there were at least two or three.
And what I would say, Your Honor, is there's
Go
cell
ahead.
phone records that should exist. My client called them or vice versa, then the cell phone records that in 2024, pretty good. If the prosecutor's office thinks that my client was calling them and telling them that, then produce those records. Say,
Well,
here's X
but
number.
counsel, I get it, but I'm not at the point of prelim or that. I'm looking, you're asking me to reduce bond. There are certain things that I'm looking at that I'm telling you that cause the court alarm. And one of those things is, if that happened, that's a huge red flag to me. And it sort of or at least counters one of the things you said about the existence of evidence in his home or not in his home. Because at some point, what's clear to me is that at some point during the course of this investigation, the defendant became aware that something was afoot. And I'm putting it that way because I don't know if he became aware he's under investigation or became aware of whatever. It may have been, maybe he was contacted by the FBI. That was the initial part of this, whatever. But then it wouldn't make sense to me why he would be, at least that's what's alleged here, contacted by these individuals or contacting these individuals to say, do X or do this. I mean, the statements that are in there they're not, well, we talk to police, tell them the truth. They're not sort of these innocuous things. They're sort of directives of what the individuals should do.
And you said it quite clear. If it's true, if the court doesn't have any evidence of that other than what's written on a piece of paper, and if they wanted proof of that.
But counsel, that argument is fine, except, I need some type of response to that, because it can't be, well, do the people have this evidence? Because if that's the case, if I take your analysis, that means in every case, despite any rule, despite anything, people just get released on everything. I realize that this is something that is fluid and that evidence kind of moves along. But I'm asking at some point, maybe the prosecutor argues first and then you can respond to it. But if you look at the particular provisions in the prosecutor's response, there are indications at the end of a few of the paragraphs where they're talking about the victim or alleged victim being in contact with your client. And that there is then the allegation that there are specific instructions about what that person is to do when contacted. So I'll let you look at that, counsel, and I've got it as I
Can I
indicated.
ask exactly where, what page is that on that you're looking? I've read through this a couple times, so I know it's in there. I just don't know where it's at.
For that portion. Right, I don't know if you can help me. There were two of them. Oh. Victim DNB is one. And the next one, victim E, the reference at the bottom,
Is there a page number here?
page 5. All right, as I indicated, the court needed to take a break at 4 o'clock to make that call to the court urgent that I have to do. So the court's going to stand in brief recess. And
All rise. May be seated.